Okay, hello everybody. For those I've not met before, my name is Dina Patel and I am a legal director in the planning and infrastructure team here at Field Fisher. Firstly, thank you all for joining us. It's great to see the names of our clients and contacts across all three of our UK offices on the attendance list. So to begin, I'd just like to introduce our speakers. So you see Chris Young QC and Thea Osmund of Number 5 Chambers, and Sue Simpson, Head of Planning and Real Estate Birmingham. So by way of brief introduction, this webinar was originally intended to be a workshop-style seminar looking at Greenbelt cases over the last 12 months. We've tried to replicate a similar approach to the webinar to give you the opportunity to ask questions and consider implications you might have on your existing sites. So I would encourage you to post any questions you have in the questions box so we can answer them best we can during the course of the next hour. Sue Simpson will collate your questions and raise them with our speakers in the Q&A section of the webinar. Of course, we're happy to talk to you further offline on topics that arise out of today's webinar, and that includes advice on the property side, including implications on option agreements and contracts. A lot of us here will have sites that have draft allocations in local plans that have failed at the first hurdle, or where the planning authority's evidence base is not obviously as robust as it might be, or indeed where the first stage hearings have been postponed as a result of COVID-19, which, if nothing else, gives rise for some reflection about the strategies we should be following. As you'll all appreciate, developing in the Greenbelt is a challenge. This makes it all the more important that your proposals are brought forward in a way that gives them the best chance of success, and you have marshalled your arguments at an early stage. Today is intended to offer some guidance on some of the issues which may arise and to arm you to deal with them effectively. The order of events will be firstly a presentation by Thea on promoting Greenbelt sites through the local plan process, followed by a presentation from Chris on Greenbelt appeals and looking for common denominators in successful appeals. We'll then have a Q&A session chaired by Sue. Again, feel free to ask any questions at any stage and we'll pick those up during the webinar and deal with them at the Q&A section. So with that, I'll now pass on to Thea for her part of the presentation.
Thank you very much, Dina. Just make sure that I'm unmuted. Hopefully I am, and you can all hear me. So good morning. As Dina said, I'm going to talk to you about promoting and assessing sites in the Greenbelt through the plan process, primarily in the context of the 2019 National Planning Policy Framework. Now, I'm certainly asked a lot about Greenbelt sites and how best to get them through the plan process. And if you've got a Greenbelt site, then engaging with the forward planning process at an early stage is a good thing to do for reasons I'll come to in due course, but hopefully I can provide some practical points for you to take away on that over the next 15 to 20 minutes. Now, in terms of policy, we're dealing with the first half of Chapter 13 of the NPPF, primarily paragraphs 136 to 139, and especially the exceptional circumstances test set out at paragraph 136, which says that once established, Greenbelt boundaries should only be altered where exceptional circumstances are fully evidenced and justified through the preparation or updating of plans. So you all know, of course, that you need to show exceptional circumstances to alter the Greenbelt, and that's at a strategic and site level. Now, the same test applies to establishing new areas of Greenbelt, but I'm going to focus on removing sites from the Greenbelt in the local plan context, and what you need to be aware of in promoting your site through the process as an allocation or an exception site, and how to support the council if you have a draft allocation. So what does exceptional circumstances mean? Well, as you will probably already know, there is no definition of the policy concept of exceptional circumstances. That was confirmed by the High Court recently in the case of Compton Parish Council and Guildford Borough Council, and that was the decision of Sir Duncan Ouseley sitting as High Court judge, and was handed down in December of last year before the world went nuts and I was still a barrister rather than a professional webinar giver. But it's a useful case because it brings together a number of principles largely already established in relation to local plans and Greenbelt alterations. But it's also 54 pages long, So I'm going to give you a quick summary and ask you to keep it in your back pockets if you find yourself dealing with Greenbelt sites in the context of a local plan. Now, the case was a statutory challenge to Guildford Borough Council's local plan, which was adopted in April 2019, and which deallocated 3 major sites from the Greenbelt for development totalling 5,200 homes, with an overall reduction in the borough's Greenbelt by 1.5%. So it was heard over 3 days, and it involved 11 barristers, including, of course, Christopher Young QC and James Corbett Bircher as his junior, and Richard Kimbling QC for the claimants, so a good number 5 outing. The challenge was brought by 3 claimants, 2 parish councils, and a Mr. Cranwell, who was a member of the Guildford Greenbelt group. There were objections to the extent of Greenbelt release generally, and also in respect of particular sites. Now, one of the main general issues was whether the inspector had gone wrong in his approach to what constituted the exceptional circumstances required for redefining the Greenbelt boundaries. It was said that the inspector had treated the ordinary as exceptional and had gone wrong in considering that Greenbelt boundaries should be redrawn so as to allow for some 4,000 more homes than the council's objective need. The need itself had reduced during the course of the examination thanks to the 2016 household projections, but there was this really generous buffer of 4,000 additional homes counted into the supply that the inspector had in fact considered sound. So in terms of the main issue and the exceptional circumstances test, there's 8 takeaways really from the judgment that I think are important, and they can be found between paragraphs 60 and 70 for the most part. So the first is this, that the fact that exceptional circumstances are not defined was said to be a deliberate policy decision. It's a planning judgment to be made in all of the circumstances of any particular case. It's deliberately broad and not susceptible to dictionary definition. So that wasn't a new principle. We already knew that from the Calverton Parish Council case in 2015 in the High Court, but reaffirmed by the court at the end of last year. Point 2, the court found that the exceptional circumstances test is a less demanding test than very special circumstances. Again, we already knew that from the Luton case in 2015. But that's why I say it's a good idea to engage with the plan process if you have a Greenbelt site. Third, as was pointed out in IM Properties Development Limited, and that was a High Court case in 2014, there is no requirement that Greenbelt land can only be released as a last resort. It may, in fact, be that Greenbelt sites are a more sustainable option than non-Greenbelt sites. Now, the test of exceptional circumstances may be satisfied by one individual exceptional circumstance. But, number 5, exceptional circumstances can also be found in the accumulation or combination of circumstances of varying natures, which entitle the decision maker to say that the circumstances are sufficiently exceptional to warrant altering the Greenbelt boundary. Number 6 is this, that general planning needs, such as the need for ordinary housing, are not precluded from the scope of exceptional circumstances. In fact, meeting such needs is often part of the judgment that exceptional circumstances exist, and the phrase isn't limited to some unusual form of housing, nor to a particular intensity of need. The judge regarded it as obviously wrong that the supply of land for ordinary housing could not in law amount to exceptional circumstances, which was one of the points that was made to him by the claimants. Now, the same must be true of other development needs, employment, industrial, etc. 7, the phrase exceptional circumstances should be considered as a whole and in its context. And the judge said it wasn't necessary to explain why each factor or the combination itself was exceptional. There is a limit to the extent to which such a judgment should be elaborated. And finally, number 8, if meeting housing need is a factor contributing to exceptional circumstances, it follows that the provision of a buffer or headroom against slippage, for flexibility to meet change and to future-proof the plan, would also contribute to such circumstances. And that was how the court dealt with this issue of the 4,000 home buffer. So another big point to be aware of for anyone engaged in plan making that involves Greenbelt release is paragraph 137 of the framework, because that tells us that before concluding that there are exceptional circumstances for the council to release Greenbelt land, it should be able to demonstrate that it has examined fully all other reasonable options for meeting its identified need for development. So, does the strategy, first, make as much use as possible of suitable brownfield sites and underutilised land? Has the plan sought to optimise the density of development in line with policies in Chapter 11 of the framework? And has it been informed by discussions with neighbouring authorities about whether they could accommodate some of the identified need for development? Those things are likely to be dealt with through the site selection process, duty to cooperate discussions and background papers, and also the sustainability appraisal. So pay close attention to that evidence base, particularly the sustainability appraisal, which of course is still fertile ground for challenge. See, for example, the recent West of England JSP. So in terms of promoting or protecting sites through the local plan process, obviously, if you have a Greenbelt site and the local authority in which it is located is looking for sites, you would be wise to promote it through the plan. That is because, as I've said, the threshold for exceptional circumstances is lower than very special circumstances, which Chris is going to talk to you about in due course. Now, the framework requires that exceptional circumstances are fully evidenced and justified, and I'm going to put some emphasis on the word evidenced. Now, the strategic issues you could leave to the council, but in relation to the site-specific exceptional circumstances, in many respects, you are best placed to provide that evidence to the local planning authority. Help the council with their Greenbelt review work insofar as it relates to your site. How does it or how does it not meet Greenbelt purposes? Make that information available if you can. Now, you need a defensible boundary. If it's a road or rail line, great. A woodland is good. Hedgerow is okay, but not so great because there may be arguments about permanence. So have you got capacity for structural planting on your site to really enhance that Greenbelt boundary? What are the sustainability credentials of your site? Now, the need to promote sustainable patterns of development is still a key feature underpinning the process of reviewing Greenbelt boundaries, for which see paragraph 138 of the framework. But once the exceptional circumstances for Greenbelt release have been established at a strategic level, paragraph 138 still gives a preference to Greenbelt previously developed sites and those which are well served by public transport. So are you able to offer some infrastructure that makes your site more sustainable? In the Compton Parish Council case, for example, one of the sites there provided a park and ride facility and a contribution towards a new railway station. Another site provided bus services and cycle routes that would enhance the sustainability of other nearby allocations. So ask, what is it that you can achieve in terms of sustainability? Now, another point worth noting from paragraph 138 is that authorities are required to set out ways in which the impact of removing land from the Greenbelt can be offset through compensatory improvements to the environmental quality and accessibility of remaining Greenbelt. Now, be alive to that issue, because it may be that there is other land in yours or your client's control which can be offered up for such improvements. But if not, think about how that can be achieved. That, in my view, is likely to be a point that's taken by objectors under the 2019 framework that requires that. So, 3 points to bear in mind when promoting your site. Point 1, engage with the council early. Greenbelt sites are always going to be contentious. The British public, as we know, has a real fondness for the Greenbelt, and it's a political hotbed, so engage and engage properly. Point 2, get the work done on site. What you disclose and at what stage of the process is going to be a matter for your judgment, probably in consultation with your barrister. But make sure you have the reports in your back pocket, because there will be a queue of people to say that your site isn't deliverable or isn't sustainably located, or that there are a plethora of sites outside of the Greenbelt that would be preferable. See, for example, as reported in the planning press over the last week, Taylor Wimpey's plans for 1,050 homes just outside of Ludlow in Shropshire, which is being promoted on the basis that it is a more sustainable option than a garden village within the Greenbelt near Bridge North that has been consulted on as part of Shropshire Council's local plan review. And I've got a particular interest in that, being a resident of Shropshire myself. So you've done all the legwork, and you're fortunate that you've got your site in the emerging plan as a proposed allocation. What do you do next? And this is point 3. Defend, defend, defend. because too many times I've seen site promoters sit back on their heels and not participate in the examination and its hearings, where 10 different parties come along to slate their site. And the council, of course, has got a big enough job to do anyway in defending the whole of the plan. And if you can be there to help out in respect of your draft allocation, well, that's great, especially so with Greenbelt sites, given how frequently and vociferously they're objected to. Now, there's a catch to be aware of, and it relates to who can appear and be heard at a plan examination. As you may already know, Section 20, subsection 6 of the 2004 Act says that any person who makes representation seeking to change a development plan document must, if he so requests, be given the opportunity to appear before and be heard by the person carrying out the examination. So you can't just submit reps supporting the plan and perhaps your site, say it's perfect and expect to be heard. You need to find a change that you want, even if it's tightening up a policy or changing the particular wording. But participate, that's my big tip. If you've got that site, you need to be there to protect it. Now, if you've got a Greenbelt emission site, you'll know that you've at least got a hill to climb. You'll have to do everything I've already said in terms of gathering evidence to support your site, and also try and find some room for your site in the plan. The reason for that is this, and it's not Greenbelt specific, but it's not part of the inspector's role to examine the soundness of emission sites, and such sites will not normally be discussed in detail at hearing sessions. The reality is you're not going to get a look in unless there is something that is wrong with the plan or the sites that have been selected that make the plan unsound. Now, if you want to get your site in at this stage, you've got to find room by arguing for perhaps a bigger housing requirement, by finding holes in the sustainability appraisal or the Greenbelt review, or by duffing up some of the other sites that are already included within the plan. The final point to think about is safeguarding. So you're not a draft allocation, you're not getting anywhere with your emission site. Is there an argument that can be made under paragraph 139 that the plan should include safeguarded land to meet longer term development needs? Now, you'll recall that one of the requirements of redefining Greenbelt boundaries, of course, is that they should not need to be altered at the end of the plan period. So if you're somewhere where it's inevitable that because the area is so heavily constrained by Greenbelt, that at the end of the plan period, the authority is going to again have to look to the Greenbelt for sites for development, then you can be arguing that land should be safeguarded for future development sites. And is your site that site that could be safeguarded for future needs? So that's the local plan process, and I'm going to put that to one side and touch on something else briefly before we move to Chris to talk more about the appeals context and very special circumstances. And that's the recent approval of the West Midlands Rail Freight Interchange Development Consent Order by the Secretary of State. So this is hot off the press. The decision is dated the 4th of May and follows the report of examining inspector Paul Singleton, who many of you will of course know from his previous life at Turleys. Now, the proposals there were for a new 297 hectare strategic rail freight interchange and associated infrastructure close to junction 12 of the M6 motorway in South Staffs. But why am I telling you this? The site was of course in the Greenbelt. Now, the National Policy Statement for National Networks provides the framework for decision taking in respect of that kind of development and recognises that promoters of strategic rail freight interchanges, it's a mouthful, may find that the only viable sites for meeting the need are on Greenbelt land. So while the policy statement doesn't reduce the protection given to Greenbelt, and very special circumstances are still required to be demonstrated, there is an implicit acknowledgement that this sort of development is needed and may be needed in the Greenbelt. Now, it should also be noted that the National Policy Statement provides a presumption in favour of granting consent for proposals that fall within the need established by that policy statement. So you have their competing presumptions and a potential weighty consideration in favour of the scheme in the very special circumstances balance. So while there were a number of harms in that case that were given significant weight, including of course to the Greenbelt, there was also landscape harm and some less than substantial harm to heritage. there are also very significant benefits. And that's something that, of course, you can achieve with very large schemes like this, which is why DCOs are so often approved. First, they get in-principle support from national policy statements, and they are at a scale that can bring really big benefits. So in terms of those benefits in this case, well, first of all, the proposals met the national need. And secondly, the interchange is anticipated to reduce HGV movements of a regional scale by over 50 million HGV kilometres every year. And so the judgment in respect of that reduction in HGV movements, that it would lead to a beneficial impact on air quality at a regional scale. So the scheme was considered to assist in the move to a low carbon economy. The proposals would also create an estimated 8,500 on-site jobs, and would also support 8,000 jobs through induced and indirect employment. The scheme was predicted to generate over £60 million through the construction activity, and once completed would generate over £680 million annually, and more than £16 million in business rates. So altogether, the judgment was that those benefits, perhaps unsurprisingly given the scale of them, amounted to very special circumstances, and the order was approved. And with that, I'll pass over to Chris, who's going to talk to you a little bit more about appeal decisions and very special circumstances.
Hello, thank you very much, Thea. Very interesting and fantastically clear and well set out. Thank you very much. I just need to check that everybody can hear and see me. I don't know if our technical people can just cut in and check that's okay for me. I have done one of these webinars with people not necessarily hearing as well as they might. There's another. Yeah, thank you, Thea. Excellent. Thank you very much. Okay, now thank you everybody for joining us today. Obviously, we're all at home. Many people have commented that my study looks like something out of Hogwarts, and I've played along. If you just look over this shoulder, that shoulder, you'll see the owl that I've got and installed for the purpose of the lockdown. Now, Greenbelt is obviously a massive issue, and in Robert Gendrick, we appear to have somebody who is prepared to be brave enough to allow development in the Greenbelt. As far as the interchange is concerned, that really was a local plan and a tap-in the concept of it having in principle approval. More contentious, obviously, are housing sites which do not have anything that supports them in terms of a local plan, and that's what I'm going to be looking at now. I'll just say this though, the position with Robert Gendrick is very encouraging. He may not be able to explain the slogan "Stay in" and what that means, or whether you're meant to go to work or you're not, but as far as the Greenbelt goes, it's all looking very, very positive. Now, I'm going to cover 7 cases in the time available. In the last 18 months, we've seen a series of inspectors allowing appeals for various forms of residential development on greenfield land in the Greenbelt, finding that very special circumstances exist. Inspectors have allowed appeals, and recommendations have been made, positive ones, to the Secretary of State in each of those 7 major appeals. 3 of them were recovered by the Secretary of State. 1 of those was dismissed by the Secretary of State, but that was just before the general election last year, and can be understood in that context, I think. Since then, more recently, during lockdown and in April, the Secretary of State allowed 2 major housing appeals in the Greenbelt on unallocated sites, and obviously he's allowed the DCO as well. Now, the position with these sites is that for years, developers have been wary of lodging appeals for sites in the Greenbelt. There are 3 main concerns. There's the perils of recovery by the Secretary of State, because up to now you generally assume the Secretary of State would recover to refuse for political reasons. Secondly, the risk of a possible cost award being made against the substance of running an appeal in the Greenbelt, because on greenfield land, because the circular specifically allows costs to be made against developers for the substance of their case in the Greenbelt. And thirdly, and perhaps most importantly, the 2015 minister's statement, which made clear that unmet housing need alone would not normally be considered sufficient to amount to very special circumstances. So a direct contrast with the exceptional circumstances that Thea has talked about and endorsed in the Guildford High Court case, where housing need in and of itself can be exceptional circumstances, but it's not enough for that to cross the threshold of very special circumstances. That was originally set out in some guidance on gypsy and travellers sites at paragraph 3.23 in 2015, and that hasn't been revoked. The government made clear it wouldn't normally, didn't rule it out completely, but would not normally amount to very special circumstances. That's housing need. And that was further confirmed by a statement by Greg Clark and Brandon Lewis, who were each acting as Secretary of State for Community and Local Government at that time. Now, despite these poor omens, as the housing crisis has deepened, some developers have been willing to run housing appeals on greenfield Greenbelt sites, and they've won. And more of these cases are appearing. They started in 2019. Appeal number one is, so there's 7 appeals. I'm just going to briefly mention them all. There is a paper that accompanies this presentation, which Dina will distribute to all of you. And you're welcome to pass that on to others as well. And that deals with each of these cases and has got a link to each of the cases as well. So you don't need to take any details as I'm going through them. The first one, West Malling in Kent, an appeal by Retirement Villages for an extra care village. Retirement Villages is owned by AXA. They became a client of mine when they appointed a new planning director. And this site was on the edge of West Malling in the Greenbelt. It was an appeal for 80 extra care apartments and cottages on a greenfield site on the edge of the settlement. Heard in December of 2019, the decision was issued by 2018. Sorry, it was issued by Inspector Robert Mellor within just 2 weeks. Quite rightly, he attached substantial weight to the harm to the Greenbelt, so you have to do that because of what the MPPF says. As well as harm by reason of inappropriateness, he found visual and spatial harm to openness and harm derived from encroachment into the countryside. So he acknowledged all the harm, making his decision bomb-proof, frankly, because he accepted a lot of harm is derived from developing on a greenfield site in the Greenbelt. But he accepted that there was a finding of very special circumstances because he placed substantial weight on the lack of a 5-year supply and the benefits to health and well-being for future elderly residents moving into the accommodation that better suited their needs. We all know about that. And individuals in 5-bedroom houses when they'd be much better off in a smaller cottage for which there's just a lack of available properties. He also gave significant weight to the absence of any credible assessment for need for elderly housing by the council. They'd used a tool advocated in the PPG, but upon examining that, it was pretty obvious that it's completely inadequate. This is the at-shop tool, if you know about that. But all it does is take the number of existing extra care facilities and projects them forward on the basis of an increase in the over 75 population. So in Tonbridge and Malling, there was actually no extra care, market extra care available, and as a consequence of which, it projected forward demand for none. And the inspector could quite obviously see what was the problem with that. So he was very unimpressed with the council's approach. They had consultants, but they clearly should have taken a more sophisticated approach. And that was part of the very special circumstances. He also noted that the local plan was badly out of date and that the site was a proposed allocation in the emerging plan. But before anybody thinks that was the secret to the success here, as had previously been the case with the big site at Brockworth in Gloucester, where 1,500 houses were released when it was a draft allocation in the joint spatial strategy for Cheltenham, Gloucester and Tewkesbury. Here, there had been no examination. It was just a site and proposed not for extra care, but proposed for housing. The council objected to the proposal, saying it was premature to the local plan. The local plan was an early stage, which is difficult to argue with when it hadn't even been examined. and also that because it was extra care and a cleverly drafted Section 106 agreement meant there was no affordable housing, then the council objected to that too. So there was no real support from the development plan process, and the inspector quite rightly acknowledged that he should give that limited weight. But if I'm being honest, I think that will have helped the inspector recognise that the council probably wouldn't come back and challenge his decision, because they'd realised the site was probably going to be given up for development in due course. And it was very well located to the high street, just beyond it. It's a relatively small settlement, West Malling. Second appeal, Station Approach, Lower Sydenham, Bromley in London. This was an appeal by Dylan 2. That's not a company you would have heard of. It's just a single vehicle company created by my very interesting client down in Bromley. And Lusada, it was a joint venture with Lusada, which is a PLC construction company. They sought permission for 151 apartments on land, which was 2/3 greenfield playing fields and 1/3 a disused single-story building. This was an old sports club associated with the Dylan company. That site where the buildings for the factory had been redeveloped, and so that had been through a whole appeal process. But now the client was coming back for a second bite, and probably in the land deal never thought that he would get permission on the sports pitches because they were designated as metropolitan open land. If you're not familiar with what that is, that's really Greenbelt in London, or London's inner Greenbelt as it's often called. Exactly the same tests apply, the tests of very special circumstances, openness. So that's why it's a legitimate case to discuss in a discussion about Greenbelt. Now, the proposal was 2 apartment buildings ranging in height from, wait for it, 9 stories to 4 stories. So a significant visual impact, but set against the backdrop of what was on the other side of a railway line, an industrial estate, and the 8 to 10 story buildings being built on the factory site that was Dylan next door. So there was context for these buildings. It's not like plonking them in the middle of the countryside. Added to which, the client was very, very shrewd, and he hired the world-leading architect Ian Ritchie. If you don't know that name, he designed the pyramids outside the Louvre, the giant glass needle in Dublin, and frankly, anything fantastic that you've seen in glass in the last 20 years. An absolute privilege for me to work with somebody like that, and I thoroughly enjoyed it. The inspector was obviously quite impressed when Ian Ritchie gave his evidence. He didn't have any time for proofs of evidence or summaries. He just got out a very high-tech projector the size of an iPhone, and then did a presentation based on his slides. And who was going to tell him that was wrong? He's Ian Ritchie, after all. Inspector George Baird, very straightforward talking Northern Irishman, found exceptional quality in the design, formed part of the very special circumstances. But he also found the council couldn't demonstrate anything like a 5-year housing land supply. That, despite the fact the council had just convinced the local plan inspector there was a 5-year land supply. But we all know how indulgent local plan inspectors can be when there's a lot of pressure on them to get the local plan found adopted. Here we were just months later, and a really clear finding that there was no 5-year land supply. The location of the site, Station Approach, as the name suggests, right next to a railway station, down which you could see straight into the City of London and Canary Wharf. The provisions for a new public park on site also significantly impressed the inspector. The MOL land in that area is nearly all private sports pitches. A lot of it was held by the banks and other institutions. There's no public access. Crystal Palace have their training ground there. And so to provide an area that is publicly accessible in a sea of inaccessible open space was a significant fact, demonstrating that you need to get the proposal right. And ties in entirely what Thea is saying, and what I advise a lot of clients in Solihull and many other Greenbelt locations, is the PPG has been, the MPPF and the PPG have been written to urge you to bring forward proposals with a probably equivalent amount or similar amount of open space to the area that you're proposing for development, because then it's an easy sell. You can say that there's a significant enhancement to access when there's been no access, and here that definitely helped the case. The inspector was so unimpressed with the council applied for costs against us, against the substance of our case. Of course, the client gets a little bit worried and thinks, are we in big trouble here? The inspector gave me 2 weeks to respond, and then he issued his decision within 4 hours of closing the inquiry, having got all those responses. So I think that was a message from him, that he was so unimpressed. The position in London is extraordinary. There's no attempt to build on Greenbelt, unlike Birmingham, unlike Cheltenham, unlike many other parts of the country. And it's completely and utterly unsustainable as a position to adopt. Appeal number 3, Great Broughton in Chester. This is another extra care scheme proposed by Castle Oak Care. The short answer to all of this is that it was part greenfield, part brownfield, with the latter being comprised of disused buildings from a redundant garden centre. The buildings obviously assisted the appellant in that case, but the inspector, Mr. S.J. Lee, one of the inspectors down at the Bristol West of England plan, he issued this while sitting there. He recognised that the harm to the Greenbelt to accommodate a large part of the scheme on greenfield land would cause substantial harm to the Greenbelt. But to overcome that, the appellants sought and relied on the same combination of factors that we had relied upon at West Malling, which was a combination of housing needs, suitable housing for the elderly, and also an argument we ran at West Malling, which is that this type of accommodation is a very efficient way to release family housing without needing to build it. A lot of people in inappropriate housing are parents. I'm sure many of you are thinking about them right now, but they are often in houses that are inappropriately large for them, and they can move to those new properties, although obviously recent events will make some people anxious about that. Extra care is not a care home, it's individually contained units, but all designed to meet elderly people's needs with an increasing component of care. And that helped the Castle Oak at Chester as well. Moving on then, and the 4th case is Boroughbridge Road in York. This was an appeal by Miller Homes for 266 new dwellings on a pure greenfield site in the York Greenbelt. It was allowed by Inspector Yvonne Wright. She treated the site as being in the Greenbelt, although that is a major contentious issue around York because they've never had a local plan, although they're about to or have just adopted one. The inner boundary had never been defined, even though the outer boundary had appeared in some policy documents. I advised Miller on this site. I wasn't available for the appeal because the Rosewell appeal just got listed and I couldn't do it. But I did encourage them to go ahead and appeal, and they were successful. The site was a proposed allocation in the draft neighbourhood plan, but then when the application went in, this allocation was deleted in the final version of the neighbourhood plan. And so the inspector attached no weight to that. More significantly, however, and the reason why we were happy to put the application in is the site had been identified as a housing allocation in the emerging local plan. And unsurprisingly, the inspector in the appeal relied upon that, albeit that the local plan inspectors hadn't reported at that stage as the examination in public hadn't taken place. Unsurprisingly, the appeal inspector found the 266 houses on Greenbelt land would result in considerable loss of openness. Yet the most interesting aspect, I think, of this case is the fact that Inspector Wright found the development would cause no harm to the 5 purposes of including land in the Greenbelt. So no urban sprawl, which recently the Supreme Court has said is the counterpart or the opposite to openness. So very difficult to understand that conclusion, but I don't imagine Miller Homes will be troubled since they've got themselves a very welcome planning permission ahead of the adoption of the York Plan. Appeal number 5 is the sorry answer or the sorry tale in this story, which is Burley and Wharfdale in Bradford, an application by CEG for 500 houses on a greenfield site on the edge of a large sustainable village with a population of 7,000. This was a call-in inquiry as opposed to a recovered appeal, which means the local planning authority, Bradford, actually itself supported the application. But the Secretary of State felt he ought to determine the appeal for himself. This is usually done at the request of the local MP. Bradford City Council has a core strategy, but they still haven't adopted the allocations DPD that they promised the core strategy inspector they would promote quickly. How often have we heard that story? Due to other constraints, the council accepted the need for 11,000 homes to be located in the Greenbelt around Bradford, but no actual sites have been selected. Therefore, the appeal site had no status in the development plan or any emerging local plan. And despite this, Inspector David Wildsmith decided that the lack of a 5-year land supply in Bradford and the location of the site on the edge of one of the main settlements warranted a recommendation for approval. Sadly, the Secretary of State dismissed it. That's Robert Gendrick in his earlier part of his career as Secretary of State. And so it wasn't really a win for the developer at all. But it must surely be recognised as one of the most significant Greenbelt releases, I think, of all of them, really, to be endorsed by an inspector for years. The inspector clearly got it, even if the ministers didn't. And I can tell you that I don't think Robert Gendrick was significantly involved. I think Esther McVeigh was significantly involved. And it turns out that her partner is the local MP for Bradford. But I'm sure there was no connection there, as advised by my lawyers. The reality is that is a negative decision if you're looking to promote, because we all fear being recovered or called in by the Secretary of State. Remember, the council was supporting that one. But there's more good news or better news this year. 2 final appeals, both in April, back to back on the 22nd and 23rd of April this year. First of all, Cheadle Hulme in Stockport, Manchester. The Secretary of State allowed this appeal on Greenfield's land for 325 houses in the Manchester Greenbelt. It was an appeal by the Seashell Trust at Cheadle Hulme in Stockport. The proposal involved a new school. The trust is a trust for children with special needs. It involved the redevelopment of an existing site, so that was the previously developed component, but all of the houses, the 325 houses, were all on Greenfield land. The inspector and the Secretary of State found there were special circumstances comprising, first of all, the need for the school to expand, and because it was for children with complex and multiple special needs, there was plainly a strong moral dimension to the need case. The houses were cross-subsidising the redevelopment of the school, so there was an enabling development component as well. But the Secretary of State also relied on the lack of a 5-year land supply of housing and the need for affordable housing as key parts of the very special circumstances case. In fact, the local council, Stockport, has a requirement for 50% affordable housing, and the trust were not proposing that. They only proposed 30%. That was obviously tied up in the viability case. But even though it didn't meet the policy compliant level, very high level of 50% for the north of England, he found that that was perfectly acceptable when you looked at the proposal as a whole. There was a clear viability case, and the housing benefit carried substantial weight. So in that very significant weight, that's paragraph 30 in the decision. So the housing component was clearly very important. Now, the last case is similarly about education, but in a different way, and a way that is probably more helpful, because with the Cheadle Hulme case, it's always going to be said, well, the school and the enabling development was a component that doesn't affect most sites. Case number 7 is the Oxford Brookes University Wheatley campus case. Unless you've been on Mars, you will have noticed this possibly been mentioned by me and others in social media and on Have We Got Planning News for You. The university was granted planning permission on the 23rd of April, the very next day after the Stockport decision. The Wheatley campus site is located within the Greenbelt. It's a large 10-storey tower and associated buildings, where many planners have been when they've studied town planning at Oxford Brookes University. That tower stands predominantly in the middle of the site and can be seen from a long way around. And all of this accommodation at Wheatley is surplus to requirements and was important for the university's redevelopment proposals, where they want to focus all their activity, unsurprisingly, in Oxford. But we didn't run an enabling case. That wasn't any part of the case. This was a straightforward argument that this was a suitable site for 500 houses in the Greenbelt. The officers recommended approval. They did so on the basis this is a draft allocation in the South Oxfordshire Plan. But again, before anybody thinks that that was a major part of the argument here, it wasn't allocated because the South Oxfordshire Plan has stalled. We know it's due to be adopted by December this year because the Secretary of State has required that. But the development was also far more extensive than the existing buildings because the university have many of their sports pitches there and also some open land. There's listed buildings around the site. There are a myriad of issues. The consultants worked on the site since May 2016. There's been a long drawn out process, but they got the officers' recommendation. The members rejected it against the officers' advice, and that was probably inevitable because in May last year, the council has changed and the conservative pro-growth, Oxford growth-focused Conservatives lost out to an alliance of Greens, Liberals and all-out NIMBY candidates who got elected on a stop-the-plan ticket. But the Secretary of State allowed the appeal following the recommendation of his inspector, Dominic Young. The Secretary of State endorsed the university's vision for the site and granted it on a number of important issues. There's a very important issue about the application of the presumption and why you can't rely on 11C in the MPPF, which says granted if the proposal is consistent with the development plan, because that requires now the development plan be an up-to-date development plan for there to be that consistency as required by 11C. I personally don't think that's necessarily right. If the plan isn't up to date, that's hardly a reason not to grant it if it's consistent with the development plan. That was perhaps the most interesting finding was the Secretary of State following the recent Cornwall case. That's the court case, Corbett and Cornwall Council, in which you don't need to be in conformity with every plan in the policy. And indeed here we're in conflict with a number of policies, but the Secretary of State still found the proposal was consistent with the development plan. So we were always going to get permission from that point on. What's interesting is the way it was handled. PDL probably was about 40% of the site as you would recognise it, car parks, buildings, student accommodation and that tower. But the new paragraph 145G is very accommodating in the MPPF and we relied upon that. But most importantly, we argued that the definition of curtilage should include the university's sports pitches. And the inspector accepted that and so did the Secretary of State. Curtilage is often tightly defined, particularly around a house, as many of you will know. But here we argued a campus is a combination of the buildings and the open space around it, and the sports pitches were part of the function of the campus. So about another 40 to 50% of the site was then treated as PDL. And because of the very liberal approach that's taken to the effect on openness in the new paragraph 145G, that meant all of that was judged appropriate or not inappropriate development. And that was extremely helpful. There was an area of land we left undeveloped because it was near to the building and had a scheduled monument on it. So we excluded that from any argument over how do we get the rest of the site away that isn't PDL, even though that was extensive. The area we're talking about was just 14%, but it was a western extension of the development. And the Secretary of State found very special circumstances to support that 14% element. He found that even though there was a 5-year land supply, we argued the point but lost it, but he found there was still a need for housing, which there undoubtedly is in Oxfordshire, and the provision of the 173 affordable units was important because the council accepted in cross-examination the need was acute for more affordable housing. But overall, very substantial weight was given to the housing benefits. There's a number of interesting other observations about heritage and so on. I cover that briefly in the notes. Now, key conclusions from what we've done so far. I'll just briefly go through this. But first of all, it's obviously beneficial if a site is a draft allocation in an emerging local plan. You see that with a number of these cases, Wheatley Campus, West Malling, and as I mentioned, the Brockworth decision from Gloucester several years ago. Secondly, it helps if you're seeking planning permission for residential development on greenfield land, if at least part of it is previously developed, as in the Bromley case, the Wheatley case, and the Chester case. Thirdly, it assists if the council accepts there's a need for Greenbelt releases on land. That was a feature in the Bradford, Bromley, and Stockport cases, and also obviously in the Westmoreland case, where the council had decided it was a proposed allocation. And that follows on from the approach taken by the inspector in the Ruddington appeal in Nottingham a few years ago. Fourth issue is, even if it's not on its own enough, the unmet housing needs can be sufficient, particularly if there's a lack of 5-year land supply. That was a feature in Bromley, Westmoreland, York, Bradford, and Stockport. Doesn't matter if you're promoting extra care, actually, you can still take the benefit of the lack of 5-year land supply. Fifth point is, it obviously helps if the site is visually well contained, and that was undoubtedly a feature of the Westmoreland site, the Wheatley site, and the Bromley appeal. The next point, the sixth point, is if development facilitates educational provision or meets educational needs, as in the Stockport and the Wheatley sites, then that clearly is a very important factor, and we've seen that before with a site in Surrey 2 or 3 years ago. And then finally, there are obviously other factors which will help with your very special circumstances case. In the Bromley appeal, it was the proximity to the railway station and the exceptional architecture and the provision of open space, the need for more appropriate housing for the elderly, and health and well-being benefits being features in the Westmoreland and Chester appeals. Perhaps most significantly, though, of all, out of those 7 appeals, 4 of them were not recovered by the Secretary of State. Now, I remember a time doing appeals for an individual house in Bromsgrove because it was in the Greenbelt, and that triggered an instant call-in or recovery. But that isn't now the case. A lot of things are not being recovered, but of course it's impossible to know that at the outset of the process. Those are the key points, and I hope that's useful. I'm now going to bring back Dina and Thea, or they're going to bring themselves back, because we're going to have a question and answer session, and Sue as well.
Thank you, both of you. That was really helpful and useful to sort of demonstrate the case for very special circumstances and exceptional circumstances. As Chris mentioned, there is a very helpful summary that Chris has produced of the cases that he's referred to, with live links that take you to the appeal decisions themselves. So I will circulate that at the end of the session. Just waiting for Thea to appear. Here we go, as if by magic.
Hello, can you see me?
Can't see you, but we can hear you.
We can hear you.
That's okay, I can't see me either, but if you can hear me, then we'll crack on in that way.
All I'd say, Thea, just because we should all help each other in these technical webinars, is if you look at the webcams thing at the top, and go down there, the first one, that may or may not work. I'm not an IT specialist, although we're all learning, aren't we?
Okay, what I'm going to do is I'll turn it off and I'll turn it back on again in the old
true
way.
fashion. Yes.
Okay.
Sue, do you want to start with a question that might be directed more towards the appeals, and I can try and use people's time efficiently with that?
Yeah, okay. So you've obviously talked to us about the very special circumstances, and you touched on the fact that draft allocations was one of the factors that would help you with a VSC application. So the first question that I've got is, what are your thoughts on the approach to draft allocations where the plans have been postponed? And should landowners just bide their time, wait for the hearings, or is your advice on the back of all these successful appeals really that people should just now start preparing their VSC applications?
Okay, 2 points. First of all, I have long advocated that if you're a draft allocation, then you should get your application in. When and if you go to appeal is a second issue, but you can obviously apply the brakes and delay matters. But I don't think you need to wait for the plan to be adopted. In most cases, The second point is obviously everybody's always nervous that they, had the gold medal in their hand and they just needed to be patient and then it be thrown away because an inspector rejected the site. That's always a possibility, but it's a very rare occurrence. It does happen, but it is a rare occurrence. It happened not on a Greenbelt site, but a greenfield site here in Cheltenham where a developer promoted a site and the local plan inspector endorsed it and the Section 78 inspector rejected it and largely ruined the site. That is always the risk. I think the key ingredient is in that case, the Cheltenham plan did progress. I think when a plan has stalled or failed, like Uttlesford, like Sevenoaks, all of those cases, I think there would be little sympathy and little risk associated with progressing an appeal, little sympathy for the council. So where they've stalled, where they haven't made progress, because actually that's what annoys ministers the most and inspectors, where councils just aren't progressing the development plan process.
Okay, thanks very much for that. The second question that we've got is a bit more specific, but on a similar theme. So they've given an example of Greenbelt authorities where the plans have actually failed at the first hurdle, and they've got a draft allocation. There's actually also housing need in this area. There's no 5-year land supply, but there aren't any of these other sort of exceptional factors, like there's not a brownfield site, there's no education or old people's housing. Could housing need and the fact that it's in the draft plan be enough to meet the very special circumstances test?
Yeah, so the ministerial guidance that was so unhelpful in 2015 and 16 was very much based on discouraging appeals, speculative applications and appeals based purely on housing need because of a lack of 5-year land supply. I think you have to see that as a product of the time, which was a minority. We've had 10 years of minority or small majority or coalition government, and Greenbelt is obviously politically toxic. But I think now, I think if a plan hasn't progressed, I certainly would advocate trying to promote a site through application and appeal. If she's back. Hello.
Hello.
Brilliant. Always better to see you. In terms of the position with these, so I would definitely say that you should go. I think a draft allocation is frankly the political green light from the Secretary of State, and you should go ahead with it. I don't know if they're your views about pressing ahead with draft allocations when the plan fails.
Yeah, I mean, I guess the plan might have failed, but the evidence base is still there to support why the site was put in the first place. So if you're looking at the circumstances that led to the draft allocation, it's not just going to be the housing need. It's going to be the fact that there's a housing need, that it can't be met in other ways. The sustainability appraisal should provide you with some evidence as to the fact that there's not sufficient brownfield, all of those things. So the evidence base remains and you can rely on that. And if it's there, and it's good solid evidence, then I agree with Chris. Obviously it's a very site specific matter, but there's no reason why, if the stars aren't aligned, that you shouldn't press on.
Yeah, I think the Secretary of State has had enough of local authorities not having up-to-date plans, and I think that's exactly what happened in South Oxfordshire, which is a cause celeb in terms of its plan, but also in Stockport. None of them have made any progress because the Greater Manchester Spatial Strategy has made no progress, because they've got the same problem we have in Birmingham with Andy Street saying don't build on the Greenbelt. They've got Andy Burnham up there saying the same thing.
Okay, thank you. And then our last question, slight change of tack, but you've talked about the West Midlands interchange DCO, and we've got a question as to what do you think are the relative merits of a planning application versus a DCO when it comes to making the Greenbelt case?
Okay,
Thea.
yeah, I can go. I mean, it's kind of apples and pears in a way, because you can't have the same process for the different types of application that would fall under those processes. I mean, in respect of the DCA process, you have national policy statements. For example, the one I spoke about in respect of the West Midlands rail interchange, that support development like that explicitly, and providing it meet the needs set out within the statement. That is then provides a presumption in favour of that development. So although you've got Greenbelt and the harm there, which provides a presumption against planning permission, you've got the competing presumption then of the support provided by the national policy statement. So a lot of people will say it's with DCOs, with those nationally significant infrastructure projects, there is very often that enormous policy support behind them that amounts to a presumption in their favour, providing they meet the criteria, the threshold set out within the document. So in some respects, there's greater support for those developments. And as I said, the one that we were dealing with, the national policy statement in respect of the West Midlands rail interchange, actually acknowledges that the Greenbelt will be the best place for some of these large infrastructure projects. In terms of making applications, as Chris said, very special circumstances, housing need isn't going to be enough. So there might be a housing need, but that's not going to sort of tilt the balance in your favour. So there are greater challenges probably in respect of ordinary planning applications that don't fall within the 2008 Planning Act process.
Yeah, and if I can just add, I mean, it obviously depends on the nature of the application. You can't use a DCA for housing. There's an element to which housing which supports an infrastructure project is allowed to be done through the application. But if you've got a housing site, the DCO is not available to you. It's just not a route you can use. There's a lot of people arguing against that, but that's how it stands.
Okay, thanks, Chris and
Thank you.
Thea.
Just to say that we've had a couple of questions that have just come through actually. So I'm going to ask them because actually they relate to a VSC case and affordable housing. So both very similar questions. One is that in the Tudor-Hume case, the level of affordable housing wasn't policy compliant, and the inspector still found that there. Found that very special circumstances were demonstrated. The question is, does this apply to paragraph 145G cases, so sort of partial infill sites cases, and can this requirement be met without providing a policy compliant level? And the second question, which came in as well, which relates to a VSC case and what weight should be given to the importance of the provision of policy compliant affordable housing, not only the percentage of affordable housing, but the tenure mix as well. So where the policies are descriptive about the tenure mixes. So it's sort of all encompassing affordable housing question.
Okay, so taking the first question first, the reality is that 145G is complete innovation. It is a very useful exercise, as I often take witnesses through a cross-examination, to look at the changes between MPPF 2012 and MPPF 2014. And to do this visually and for it to work in cross-examination, I just highlight the new text, put it next to the old text, and point out what's new. And what is really significant is that you don't need to effectively have no impact on openness, which is impossible anyway. And you do need that component in one of the limbs of 145G. There's 145G 1 and 2. You do need that affordable housing. It isn't explicit about how much. So at Wheatley campus, it wasn't that we were providing an exception site or meeting all the affordable housing need or providing just affordable housing. It's just the generic provision of it. Now, if people are saying to me, leave aside Tudor-Hume's position of a enabling development case, and that obviously wasn't what we were doing at Wheatley campus, then I don't think you would run a case in the Greenbelt where you tried to underprovide the affordable housing. You'd only do that on a viability basis. A, you'd have an objection on policy ground, and B, you might as well take a gun out and shoot your own foot off. Because if there's one thing that wins an appeal, it is the delivery of affordable housing. So there's no way you'd underprovide it. And I don't know who asked that question, but whoever the landowner is in your land option, the landowner needs to behave, okay? Because to get home in the Greenbelt is hard enough. And I have to be very stern with landowners sometimes. They're always thinking, well, perhaps we could have we could reduce the affordable. And I say, stop being so greedy and realise if you get home in the Greenbelt, you are basically winning a gold medal in the 100 metres in the Olympics.
Thank you. Thank you for not sitting on the fence.
Yeah. It just makes me so furious when people say, can we chip the affordable? Really? Do you have any idea how to win? Sorry, Dean, the second, I got a bit overexcited there, didn't I? The second part.
The second question was about affordable housing and the percentage, but also the tenure mix. So I guess two scenarios. One is that you're trying to reduce the overall percentage, and the other one is to mess about with the mix, which developers often want to do because there's market reasons that the council's mix doesn't necessarily work.
Yeah, I mean, what often drives this is a minimum land price or a deal where the landowner is expecting a certain amount of money, and who am I to criticise that if that's your way of getting the site? I do a reasonable cottage industry in producing advice, usually about the third day of the inquiry, explaining to the landowner why it would be in their interest to accept what the council wants for the affordable housing, rather than trying to ruin their own case of appeal. But the reality is, with the tenure mix, you need to be intelligent about it. Often, a lot of councils are not asking for social rented because, as Nick Clegg observed when he left the government, George Osborne, he couldn't remember which one it was, but either George Osborne or David Cameron said to him, why do you keep going on about social rented? There's no votes in social rented for parties like ours. And that may well be true. And at the local level, a lot of councils think there's nothing in the social rented. So they move to affordable rent, or they try and cut out rent altogether and just go for intermediate. Now, that's fine if you're trying to convince the council and they don't want much social rented at the application stage, but at appeal, you need to be absolutely certain that you are matching what your evidence is showing. And that often shows an absolutely acute need for social rented housing, which has collapsed. So it's at which level you're at. I'll give you an example of that, not the Greenbelt, but I did an appeal for Barratt last year in Trentham, in Stoke-on-Trent, and there the council wanted to off-site all the affordable because Trentham is one of the rare parts of Stoke that has a strong housing market, and as a consequence of which they wanted to provide it more efficiently elsewhere. But we're in front of an inspector, and we took the decision that we would match the SHMARS requirement for the tenure and not off-site the affordable at all. So you might think, well, that doesn't help the landowner, but we were trying to win an appeal on an unallocated site. So it's all about at what level you're playing. Are you playing against the authority for an application, or are you playing at appeal and you're trying to convince an inspector?
Okay, great. I think that brings us to the end of our questions. Thank you both. We've got a recording of the webinar, which I will share, because somebody has asked a question about that, so I will share the recording as well. And thank you to Chris and Thea for allowing us to share the recording. I will share the note as well, which I've seen before and is very helpful and very useful, giving you the links to the actual appeals as well. So once again, thank you both for your time. Thank you very much, and hopefully at some point we will be able to do an in-person seminar with beers and Prosecco and some networking opportunities at the end of it. So thanks very much, and thank you, Sue, for chairing the questions.
Thanks everyone.
Thank you very much, everyone.
Bye-bye.
Bye.